5 seconds to go. Start. The High Court has also directed that the respondent shall also be entitled to retiral benefits on the basis of continuity of service with effect from date of his dismissal and till his superannuation. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court dismissing the writ petition and confirming the order passed by the Industrial Tribunal, setting aside the order of dismissal and ordering reinstatement with continuity of service and back wages, the MSRTC has preferred the present appeal. Miss Mayuri Raghuvanshi, learned counsel appearing on behalf of the appellant MSRTC, has vehemently submitted that in the facts and circumstances of the case, the industrial court committed a grave error in interfering with the order of dismissal passed by the disciplinary authority on the ground that the same is shockingly disproportionate to the misconduct proved. It is submitted that both the High Court as well as the Industrial Court have not at all considered and or appreciated the difference between the disciplinary inquiry and the criminal proceedings. It is submitted that the High Court as well as the Industrial Court had erred in relying upon the acquittal of respondent in criminal case. It is submitted that the Industrial Court and the High Court have failed to appreciate that the acquittal has no bearing or relevance on the disciplinary proceedings, as the standard of proof in both the cases are different and the proceedings operate in different fields and have different objectives. Reliance is placed on the decisions of this court in cases of Samar Bahadur Singh versus State of UP and others 2011 9 SCC 94 and Union of India and others versus Sita Ram Mishra and another 2019-20 SCC 588. It is further submitted that in fact the Labour Court rightly held that acquittal in the criminal case would not come to the rescue of the respondent, as the acquittal in the criminal case is on the failure of the prosecution to examine investigating officer, punch for sport panchnama, etc., and to prove their case beyond doubt. It is submitted that on the other hand, in the departmental proceedings, misconduct has been proved. It is therefore submitted that the Industrial Court and the High Court ought not to have given undue importance to the acquittal of the respondent in the criminal case. It is further submitted that even otherwise, in the facts and circumstances of the case, when in the vehicle accident 4 persons died due to the negligence on the part of the respondent in driving the vehicle carelessly and negligently, and during his 3 years tenure he was punished 4 times earlier, it cannot be said that the punishment of dismissal was shockingly disproportionate. It is submitted that in the facts and circumstances of the case would not fall under item number 1G of Schedule 4 of the MRTU and PULP Act 1971. it is further submitted that even the industrial court specifically observed in the order that the misconduct is not of a minor or technical character. It is further submitted that the industrial court also observed that there is no victimization and the action of the MSRTC cannot be said to be not in good faith. The industrial court also observed that the MSRTC has neither falsely implicated the complainant respondent nor has it dismissed the respondent for patently false reasons, and therefore respondent failed to prove the alleged unfair labor practice as per the MRTU and PULP Act 1971. It is submitted that, however, the industrial court has interfered with the order of punishment dismissal imposed by the disciplinary authority invoking clause 1G of schedule 4 of MRTU and PULP Act 1971. It is further submitted that even the respondent admitted that he was gainfully employed after his dismissal. Therefore, the order of reinstatement was not warranted at all. It is further submitted by the learned counsel appearing on behalf of the appellant that even otherwise the directions issued by the High Court in the impugned judgment and order in para 8 directing the appellant MSRTC to pay to the respondent back wages with effect from 1st November 2003 to 31st May 2018 could not have been passed in a petition filed by the appellant MSRTC. Stop.